Thank you, Madam Chair. Dear Madam Chair, dear Rapporteur, dear members of the Committee of Budgetary Control, I thank you very much for your interest in our special report. As the responsible member, it is my pleasure to provide you with an overview of our work and observations in the report. Import procedures, shortcomings in the legal framework and an ineffective implementation impact the financial interest of the European Union. This year marks the 50th anniversary of the customs union. The absence of customs duties between our member states and the establishment of common customs duties on imports from third countries. While internal borders are abolished in favour of free circulation of goods in the European single market, goods entering into this market from outside the customs territory of the European Union remain subject to customs controls and payment of customs duties. These duties form a major part of the so-called traditional own resources of the Union and are an important source of revenue for the European Union budget. In 2016, these traditional own resources made up 14% of the European Union revenue, equal to 20.1 billion euro. Deliberate evasion of these customs duties occurs through undervaluation, misdescription of origin, misclassification, or a combination thereof. This evasion increases the customs gap and must be compensated by higher contributions by member states via the GNI resource. So this cost is ultimately borne by European taxpayers. For this special report, we assessed whether the Commission and the member states have designed robust import procedures that protect the financial interest of the European Union. We visited the customs authorities of 5 member states, resulting in a range of observations. We found that the current system does not prioritize the importance of customs duties as a source of financing of the European Union budget, and currently no estimation on the customs gap is made. Estimating this gap and its components is important for targeting customs controls. While member states' customs authorities are responsible for the collection of customs duties, we found a disincentive for member states to carry out customs controls. Since the Commission can hold a member state financially liable in case of administrative errors, those member states which don't carry out customs controls may not face this risk. The implementation of the Union Customs Code is underway, yet the supporting IT infrastructure and means of exchange and communication of customs information have not reached their full potential. The cooperation and exchange of information with non-European Union countries is gaining momentum, and European Union action programmes such as Customs 2013 and Hercule II have improved knowledge sharing and cooperation between member states. Further progress has been made towards the uniform application of customs legislation, including the integrated customs tariffs and measures database TARIC. Yet some shortcomings remain. While we are pleased to see that the Commission has followed a previous European Court auditor's recommendation to implement binding tariff information, still no European Union-wide evaluation decision exists. We found that a lack of uniform approach to customs controls of imports by Member States can lead to underpayment of customs duties. This distorts the choice of Member States of importation, so-called import point shopping. We found that Member States which carry out fewer customs release controls attract more imports. This is particularly evident in the case of controls related to undervaluation of textile and footwear from China, where Member States which don't carry out customs release controls attract traffic from other Member States. One single Olaf case has found potential losses of customs duties and VAT due to undervaluation of imports of textiles and footwear from China into the United Kingdom of close to €2 billion for the period 2013-2016. Analysis of the implementation of customs control revealed further inefficiencies such as different approach in tackling origin classification fraud and regarding penalty regime. The real origin of goods can be disguised via fraudulent transshipment in a country where the goods are stored temporarily and then sent to the European Union with fake documents. Loopholes remain as Member States don't carry out pre-arrival checks to protect the European Union financial interest and don't always carry out the controls suggested by their risk management. Furthermore, the level of post-release controls is insufficient to offset the decrease in controls on simplified procedures, and these controls rarely cover imports in other Member States. Goods below a certain value are exempt from customs duty under the so-called low-value consignment relief. We found that a lack of checks is leading to underpayment of duty on goods declared as low value, purchased online from outside the European Union using e-commerce. Evidence gathered by the United Kingdom on e-commerce points to massive undervaluation of goods imported from the Far East and increasingly the United States of America by a factor of anywhere between from 10 to 100 times below the correct valuation. In conclusion, in this audit, we have found shortcomings in the legal framework as well as in an effective implementation of customs controls by Member States, affecting the financial interest of the European Union. We therefore make a number of recommendations to the Commission aiming to strengthen a legal framework and its application. At the same time, we recommend the Member States to improve and adapt the systems in place regarding customs controls and investigation plans. Madam Chair, Rapporteur, Member of the Committee, allow me to conclude by thanking the audit team involved for their performance on this task. I remain at your disposal for any questions. Thank you.